Welcome to the April 2026 edition of This Month in Payroll. I'm Claire Soccio, National Leader of PwC's Workforce Practice. In this month's edition, we'll focus on the Fair Work Commission's junior rates decision, new regulator guidance about New South Wales Long Service Leave, and two judicial decisions impacting the SCHADS and higher education awards. First, to a significant Fair Work Commission decision that will directly impact employers in the retail, fast food and pharmacy sectors. On the 31st of March, the full bench of the Fair Work Commission handed down its decision in an application brought by the Shop, Distributive and Allied Employees Association, the SDA, to vary minimum wages for junior employees under three modern awards: the General Retail Industry Award, the Fast Food Industry Award, and the Pharmacy Industry Award. Under current arrangements, employees aged 18 to 20 are paid a discounted percentage of the adult minimum wage, being 70% for 18-year-olds, 80% for 19-year-olds, and 90% for 20-year-olds. The SDA's application sought to remove junior rates entirely for employees aged 18 and over, and to increase the rates for workers under 18. This was conducted as a major case, with 87 witnesses, including 5 expert economists, and extensive submissions from employer associations, including the AI Group, the Australian Retailers Association, Master Grocers Australia, and the Pharmacy Guild. For employees aged under 18, the full bench decided to retain the current junior rates. Retaining the graduated rate structure was considered appropriate, given restrictions on child employment, availability constraints, and lesser maturity, life experience and work experience of juniors. For adult junior employees aged 18, 19 and 20, the full bench decided to remove the graduated rates, finding there was no substantial difference in the value of work compared with employees aged 21 and over that justified reduced wages. In fact, the evidence consistently showed that young adults performed the same duties, used the same skills, and worked under the same conditions and with similar responsibilities as older colleagues in the same classifications. However, there is one important distinction or carve-out. The Commission has decided to retain discounted rates for young adults who have 6 months or less experience with their current employer. During that initial period, the existing percentages of 70, 80 and 90% will continue to apply for 18, 19 and 20-year-olds respectively. This is designed to balance the needs of inexperienced workers entering the labour market, while recognising that experienced young adults should be paid at the full adult rate. The changes will be phased in over approximately 2.5 years, starting from the first pay period after 1 December 2026, and increasing in increments of 5 percentage points at roughly 6 monthly intervals. 20-year-olds with more than 6 months service will reach the full adult rate by July 2027, 19-year-olds by July 2028, and 18-year-olds by July 2029. The Commission will hear further from the parties on the final transitional arrangements before making formal determinations. So what are the key considerations now for impacted employers? First, there's a need to assess workforce exposure and model the cost impact. While the phase timeline does provide some breathing room, employers in the retail, fast food and pharmacy sectors should begin planning now. This means understanding the current composition of your workforce by age and tenure, modelling the cost impacts over the transition period, and factoring this into budgets and workforce planning. Prepare for payroll system changes. The phased implementation introduces new variables, age plus length of service with the current employer, that payroll systems will need to track accurately. Given the staggered transition, system configuration and testing should begin well in advance of December 2026. Review enterprise agreements and over-award arrangements. Employers with enterprise agreements will need to assess their EA rates against these award changes and consider the impact on future bargaining strategy and negotiations. Where EAs or contracts already provide rates at or above the new minimums, the practical impact may be limited, but this should be carefully reviewed and verified against each step of the phase-in schedule. And finally, given the expert evidence that employers may consider substitution towards younger workers as a cost management strategy, Any workforce planning decisions should be made carefully, lawfully, and with an eye on broader compliance obligations, including anti-discrimination laws. We'll continue to monitor the Commission's updates on final transitional arrangements and will keep you updated as they are confirmed. As flagged by Alana in last month's episode, on the 1st of March 2026, New South Wales Industrial Relations released a new Long Service Leave guide detailing how it intends to administer the New South Wales Long Service Leave Act going forward. Importantly, the underlying legislation has not changed. Rather, the new guidance reflects changes in New South Wales IR's interpretation of the 1955 Act. New South Wales IR has indicated these changes will be applied prospectively and will not impact prior enforcement activity. Today we will highlight several key changes when compared to their earlier published guidance. First, how to assess continuous service for casual employees. When determining a casual employee's entitlement to long service leave, New South Wales IR now proposes that each casual's pattern of work should be individually assessed under a two-step approach. First, establishing whether the casual's engagement constitutes a series or pattern that gives rise to an ongoing employment relationship akin to continuous service. And second, characterising any interruptions or breaks to that pattern. The assessment needs to be made on a case-by-case basis, considering the regularity of engagements, the time between them, and the reasons for any interruptions. In practice, this requires a detailed, fact-specific analysis of payroll and rostering records for each casual worker, which will be a significant undertaking for employers with large casual workforces. Second, how to calculate ordinary pay. When calculating the rate at which to pay long service leave, the Act provides for different methods depending on whether the eligible worker has a fixed or a variable rate of pay. New South Wales IR now considers that a worker who is entitled to or eligible for a bonus or incentive payment has a variable rate of pay. This triggers the averaging method, where the higher of the worker's average weekly ordinary pay over both a 12-month and a 5-year period is payable for long service leave purposes. In practical terms, this change has the potential to capture salaried employees who participate in bonus and incentive schemes, and possibly those who receive other additional payments, such as award true-ups. This is a much broader population than the Commission and piece workers to whom the averaging method was previously understood to apply. Thirdly, how to treat employees with fluctuating hours. Where a worker doesn't have a normal weekly number of hours of work, such as casual employees and part-time employees regularly working beyond their contracted hours, New South Wales IR considers that an additional calculation is needed to determine a deemed normal weekly hours figure before calculating that worker's ordinary pay. While this appears consistent with earlier guidance, the new guide sets out the expected approach in expanded detail and with prescriptive formulas. And fourth, the rate of accrual after 15 years of continuous service. Earlier published guidance suggested that workers would only accrue long service leave benefits for each completed year of service after 15 years. The new guide now recognises that workers are entitled to a pro rata accrual, including for whole and for part years of service beyond 15 years. The New South Wales Long Service Leave regime remains complex and nuanced, particularly for casual employees and those eligible to participate in bonus or incentive schemes. Employers with New South Wales workers should review the new guide carefully and consider any changes to payroll system configuration and supporting processes needed to accommodate the prescriptive calculations now expected by New South Wales IR. While the underlying law has not changed, the guide does provide clarity about the regulator's expectations. Any employers with current complaints or active audits with New South Wales IR should also consider the potential impact of this revised interpretation on those ongoing matters. And finally, 2 quick updates in respect of industry-specific federal court decisions, both of which overturn previous decisions we've discussed. The first relates to the Social, Community, Healthcare and Disability Services Award, or the SCHADS. You may recall that in January we discussed a decision of the full bench of the Fair Work Commission concerning the treatment of sleepovers under the SCHADS award. That decision found the award was ambiguous about whether a sleepover is a break between shifts and whether work performed immediately before and after a sleepover constitutes a single shift for the purposes of shift penalties. The full bench proposed to vary the award to clarify that sleepovers are not breaks, and that work performed immediately before and after a sleepover should be treated as one continuous shift. There has now been a relevant federal court decision which adds another dimension to this issue. In the case of Fair Work Ombudsman against JATS Joint Proprietary Limited, the full federal court dismissed an appeal by the Fair Work Ombudsman, holding that, under the current award, a sleepover is a break between shifts and not part of the shift itself. As such, the sleepover period is not counted when determining whether a shift finishes after midnight or starts before 6 a.m. for night shift loading purposes. Entitlement to night shift loadings should instead be determined by considering the times of the shifts worked immediately before and after that sleepover period. For employers covered by the SCHADS award, the JATS joint decision provides some clarity about the treatment of sleepovers under the current award. However, the Commission's proposed variations may change that position going forward, and employers should closely monitor future developments. The second update relates to the Higher Education Industry Academic Staff Award. In July last year, we discussed two federal court decisions that considered the boundaries of associated working time for casual academics. One of those cases, Torrens University against the Fair Work Ombudsman, has now been resolved on appeal, in what represents a notable development for the higher education sector. To briefly recap, the original dispute centred on whether marking assessments for a subject as a whole, rather than for a specific lecture, should be separately remunerated at the award's marking rate, or whether that marking rate falls within the associated working time already compensated through a composite or lump sum lecturing rate. The primary judge found in favour of Torrens University, holding that associated working time includes marking of all assessments relating to the content taught by the lecturer, and was not limited to marking directly related to a single lecture. At the time, we flagged that the Fair Work Ombudsman had immediately lodged an appeal. On the 17th of March, a full bench of the Federal Court allowed that appeal, concluding that marking of assessments that are not directly linked to a specific lecture or tutorial should not be absorbed by the composite lecturing rate and should instead be paid separately at the applicable marking rate. The compliance notice originally issued by the Ombudsman to Torrens University has therefore been confirmed. Justice Michael Lee noted that the composite lecturing rate and its associated working time allows for 1 hour of lecture delivery together with a limited body of work associated with that delivery, which is principally preparation but potentially includes marking a test administered during the lecture or speaking to a student at the end of the lecture. Any other marking of assessment tasks should be remunerated under the separate marking rate provisions when performed. In practical terms, this means the Ombudsman's narrower interpretation has prevailed. This is a significant reversal for the sector. Universities and other higher education providers that have relied on the earlier decision or adopted similar practices to those of Torrens University should now review and reconsider their current payroll practices and how they are categorising and paying marking activities performed by casual or sessional academics. If necessary, employers should also consider historical practice and whether remediation is required for past payments. And that's it for our April edition of This Month in Payroll. If you would like to revisit any of our prior updates, they're available on our website at pwc.com.au/payroll. And if you have any questions or need for support, please reach out to me or your usual PwC contact. Until next time, have a great month in payroll.